Mhm.
Okay, so hi, I'm Carly, and I'm going to be talking about harassment in the workplace. Harassment is discriminating against an employee or unwelcome conduct, usually based on race, color, religion, sex, national origin, age, disability, or genetic information. One question people usually ask is when something becomes harassment that it's illegal. If enduring the offensive conduct becomes a condition of employment, so if it's something that the employee has to get used to, they come to work knowing that they're going to get harassed by a person, that's usually not good. And when the conduct is severe enough to create a work environment that's hostile or abusive, and this isn't just to the person that's getting harassed, it can also be to the other people around them. If there's other people in the office who feel uncomfortable around a certain person because of what they do to someone, then that's also not good. Harassment is usually offensive conduct, and offensive conduct is offensive jokes, slurs, name calling, intimidation, ridicule, mockery, insults, putting someone down, and interfering with work performance. So pretty much just making fun of someone for something that they can't control. Usually, this kind of thing can come with a lawsuit, so harassment can get extreme as to someone quitting and then filing a lawsuit, which can make a company have to put out a lot of money for lawyers, law things, and stuff like that. Okay, so as I said, the effects of harassment at work, it creates a hostile work environment, not just for the person being harassed, but everyone around them as well. It promotes poor moral, it's expensive if you have to go over for lawyers, financial settlements. It can also have psychological damage to the person that's being harassed. One thing that comes with harassment is confidentiality. Normally, a person who's being harassed won't go right to their HR or their supervisor and say, I want to file a formal complaint. It'll normally be more in the terms of, can we talk, like just me and you? And as a person working in HR, you have to know if you can keep something between you and the other person, or if it's something that you can't. Because a lot of times you can't keep a matter confidential. You'll have to investigate, which involves a lot of interviews. You have to interview the person's supervisor. You have to interview the person who is being harassed, the person who's harassing them. And also you have to have a lot of proof. You have to make people sign stuff, even if it's just a warning. I have an internship right now in HR where a person came to the HR manager saying that they wanted to talk about a person who they felt was harassing them. And even though the person just got a warning, they had to sign a paper saying that I'm aware that I've been warned that I have been harassing this person. And even if it's just a warning, so that when they come back to try and file a lawsuit, you have proof that the person knows that they were doing something wrong. So one of the most common forms of harassment in the workplace is sexual harassment. This is seen the most. HR can't decide whether or not to believe an employee. Rather, they have to take his or her word. Again, a lot of interviewing. They have to ask witnesses around them what they saw happening. They have to ask supervisors if they knew what was going on, if they said anything to the person that was being harassed or to the person that was harassing them. So again, at my internship, the first week, this girl came to the manager, and the first thing the HR manager did was call the girl's supervisor and said, do you know that this person feels like they've been harassed? And the supervisor had no idea. So you just have to make sure that everyone around them knows, interview, make sure you talk to witnesses too, who are just a third party. There's 3 laws that harassment goes against. The first one is Title VII of the Civil Rights Act, and this prohibits employers from discriminating against employees on the basis of sex, race, color, national origin, and religion. The second one is the Age Discrimination in Employment Act of 1967. This protects employees over 40, and this also goes with hiring, firing, discrimination, promotion, and compensation. And then the third one is Americans with Disabilities Act. So same thing, but people with disabilities, making fun of people with disabilities is considered harassment and is illegal. The most important thing to remember when you're a person working in HR is that the employer is liable for any harassment claim. So when employees come back and say that they've been harassed, it's not on the person that was harassing them, it's not on their supervisor, it's on the entire company. So everything, and when it comes to harassment, everything goes case by case. They see if it's illegal based on that specific case. And this is why HR has to make sure that they document everything and make sure that they put it in a person's HR file, make sure the person that was witnessed anything have a signature, the person that was harassing someone have a signature knowing that what they were doing is wrong, a supervisor signature, and even if it's not a formal complaint, it's important to do this. And like I said, the most common one is sexual harassment. At my internship, that's the only kind of harassment that I've ever seen so far. And there's a lot of warnings that go out. We have a warning paper, a formal complaint paper that everyone has to sign and make sure that they know what they're doing is wrong, so that if someone comes back, the company has proof that the person knew what they were doing was wrong. Okay.
Hi everyone, I'm Taylor and I'll be talking about hiring and all the laws that come along with it. So on paper, recruiting new employees might appear to be a simple process, but in actuality, it's actually a very complex process that every step of the way you have to be aware of the certain legal implications that come along with it. So that's what I'll be talking about today. So when you're hiring for your company, the first thing you do is post a job advertisement. With job advertisements, you have to be careful with the wording. So like that is something you wouldn't want to post. Before even meeting someone, before even meeting a prospective employee, the employer may be illegally discriminating against them with these job advertisements. So some things that you don't want to say would be like hiring recent college graduates, because that's discriminating against an older worker, and also hiring salesmen, because that suggests that only men can apply for the job. So you just want to be careful with the wording, not to preference a person's race or gender or age or something like that. So next is the job application. With the job application, you want to avoid asking questions that about personal characteristics. So things like birth date, graduation date, salary history. Although these things aren't illegal in many states to ask, it can be used as evidence for an employer's intent to discriminate against the applicant. Like, so if a date of birth, somebody can come back and say, you didn't hire me because I was too old. So you just want to avoid that completely. Actually, at my internship that I'm at right now, we're working on taking like those questions off of job applications just to avoid that altogether. Ban the Box it's a campaign started by all of us or none of us, and it's made up of ex-convicts and their families. And it's basically urging employers to take the question, have you ever been convicted or have you ever been found guilty of a crime, off of the job application, so that employers hire employees based strictly on their qualifications and their skills and not on their past convictions. And actually over 45 cities have removed the question regarding past convictions off of their job application. And my internship where I'm interning is actually in the process of doing that as well, to give everybody a fair chance.
Or in Philadelphia, Pennsylvania?
In New Jersey. So next up is interviews. So during interviews, which I'm sure you've all been on before, an interview process is about assessing an applicant's match to the position that you are looking to hire for. Certain questions during an interview are illegal, and they're questions that you shouldn't be asking an applicant. These are personal questions and questions about classes that are protected by the law. Some of these questions are, do you have a disability? Have you ever filed any workers' comp claims before? Stuff about marital status, the applicant's race, religion, their sexual preference, things of that sort. If these questions are asked, they may be considered evidence of intent to discriminate by the employer, by the EEOC. So you just want to be careful what you're asking the applicant during the interview process. Some questions that are okay to ask, or I'm sure you've all heard before, basic interview questions like, what are your skills and qualifications? What makes you qualified for this job? Your past experience, past work experience, why you want to work for the company. Those are all okay questions to ask as an employer to the applicant during the interview process. So before an employee can start to work, there are some things that employers like to do, like a background check, checking their references, or a pre-employment test. When checking references, it's basically the same rules that apply to when you're asking questions to an applicant. Like you can't ask the reference about disabilities or the applicant's race or anything like that. With background checks, that includes like criminal records, driving records, social security, credit report. You have to be keep in mind state and federal laws. So in some states, it's actually illegal to not hire somebody because of their credit report, but in other states it is legal. So you just want to be mindful of that. Some pre-employment tests are like fingerprints and drug tests. They also have to be relevant to the job. So if you're hiring a driver, you can do a driver abstract because you'd want to know a driver's driving history if you're hiring them. So before you can do these pre-employment tests, an employer has to offer a post offer, and it's basically a formal job offer to an individual, but it's contingent on completion of these tests. So you have to say if you pass these tests, then you'll be hired for the job before they can start, like the drug test and the fingerprint. And also before they start working, you want to make sure that you work out the details with the employee. When making a formal offer to an applicant, you want to work out and make sure that the pay offer is strict basically on the skills and responsibilities required for the job that they are about to start. You also want to work out all the little details with the applicant before they start working. So after all this, you can finally hire your applicant and they can start working for you. So as you can see, prior to and during the hiring process, prospective employees have a number of rights under the law. And during the hiring process, you also want to avoid making promises to the new employee that you may not be able to keep. Recruiting and hiring is a complex process, and every step of the way, you have to be aware of the certain legal implications that come along with it. And also, discrimination is the biggest concern during hiring and recruitment. You want to make sure not to discriminate based on someone's race, gender, sexual orientation, things like that. Also, it's most importantly to have equal opportunity for every job applicant and just to give everybody an equal chance and hire job applicants based on their skills and qualifications and not on their personal characteristics. Thank you. I would now like to introduce Nick, who will be talking about termination.
So hi, I'm Nick. My topic is about the legal processes of laying off employees. So unlike hiring employees, laying off employees is a more unfortunate part of the job. It's very stressful and awkward for all parties involved. So the topics I'm going to be talking about are mainly employment at will, how termination should be conducted, and the differences between individual layoffs and larger downsizing in general. So employment at will is a labor law where an employer can terminate an employee at any point at any time. It's not as simple as the law makes it out to be. There's lots of exceptions that can create illegal forms of firing called wrongful termination. So when this happens, employers have to prove that the reasons that they fire someone is justifiable, no discriminatory reasons or harassment reasons. When determining a wrongful discharge, actually, the first thing you need to determine is that someone actually got laid off to begin with. There's actually lots of disputes of whether a person was actually laid off or quit on his or her own terms. it's legally possible for an employer to create intolerable working conditions designed to make an employee quit on purpose. When this happens, the plaintiff must make a case for constructive discharge. So really, you don't have to fire someone to be charged with illegal termination, which is kind of funny. A little bit of history behind it. Employment at will, which I discussed earlier. Originally, the law was a lot more pure in how they handled it. It wasn't until 1937 with the National Labor Law where you had to, where it became illegal for someone to be fired based off of whether or not they're part of a labor union. So one of the first grounds for legal for employment at will exceptions is breaching an implied contract. An implied contract is when an employer makes a promise of job security and they don't keep it. So in order to determine if it's legally binding, first thing you want to do is make sure a promise was actually made, preferably in writing, whether the source of the promise was made by someone with sufficient authority behind it, and make sure that the promise wasn't highly conditioned with an effective disclaimer. So another employment at will exception is when an employee is fired for supporting legal laws or public policy in general. This includes whistleblowing, which involves reporting company wrongdoings to the public. Under this, the plaintiff must show that the policy was relevant to their conduct, that discouraging their own actions undermined this public policy, and that these actions actually led to their termination. They also have to prove against any overriding justification. So you can't whistleblow and also skip 20 days of work. There's other employment at will exceptions, stuff like discrimination, when you fire someone if they're part of a protected class like race, gender, religion, stuff that was covered earlier quite a bit. There's other illegal reasons to fire someone, like refusing to return sexual favors or acts that are really outside of their job description. So overall, a wrongful termination can't be brought absent termination or constructive discharge. So alternatives to this should be considered like retraining, transferring, demoting, or executing last chance agreements. Employees can be encouraged to resign, but as I talked about earlier with constructive discharge, you have to tread lightly in that area to make sure you're not pressuring them. So you want to be overall reasonable and dignified manner. You don't want to kick them out a window. You want to be, despite any hurt feelings that happened. And that goes for both parties. So the second half of this topic is on terminating larger numbers of employees at the same time. This is slightly different legally than terminating individual employees. So a little bit of vocabulary, downsizing. It's the reduction of an employment force, and it's a term used to refer to the terminations of numerous employees at the same time, or to cease entire operations entirely. Planned closing, which is when you temporarily or permanently close an entire building that results in the employment loss of at least 50 full-time employees. There's also mass layoffs, which is a reduction in force that's at least 500 employees or 33% of the employment force. So employers regularly downsize, whether it's because of outsourcing, reduction of staff, low income, and the law doesn't provide employees with a lot of good ways of challenging these reasons. One of the reasons, which I discussed earlier, which is the National Labor Relations Act. This is done in two ways, whether or not you discriminate against them for being part of a labor union, or you don't barter with the labor union first, which are sometimes legally obliged to do so. You want to inform the employees about 60 days before the employers are terminated. send them a written note. So overall, conducting layoffs is a really delicate topic, both in practice and legally, and should be trended very carefully by those responsible for the action. Next up is Megan with disability.
You're fine. I was gonna say, how do you see? Well, hi, I'm Megan. Is that on the timer? Yeah, so confused. Okay. So about 1 in every 5 Americans have a disability. So with that being said, you're most likely going to work with somebody that has a disability. And even though there's different types of disabilities that obviously, like, so say like autism, no disability is going to be the same and no person is the same. So your experience every time is going to be different. A person can show that he or she is disabled in 1 of 3 ways. So they could have a mental disability or condition that limits a major life activity like walking, talking, seeing, hearing, or learning. They could have a physical impairment like the one in the picture. And then lastly, even a history of a disability such as having cancer that's in remission is something as well. And then the Rehabilitation Act of 1973 served as a model for the Americans with Disability Act of 1990. This was the first civil rights act that granted disabilities and protects them from being discriminated in employment in local and government jobs. And then this is George W. Bush signing the ADA Act.
Who is that?
George H. W. Bush. Yeah. And then there's 5 titles to the act. So it's employment, state and local government, public accommodations, telecommunications, and miscellaneous provisions. This is with the Disney campaign, the Princess campaign. I kind of brought it up because a lot of these were like people's role models growing up, and it kind of just goes with the question, would you still value them the same if they had a disability? And then although harassment is illegal, teasing and offhand comments still often happen. The laws are great to have in protecting people, but it still has not eliminated many issues that allow independence and freedom. So not only is this a problem in the workforce, it's a problem in schools as well, which affect faculty too, because they have to deal with it. So then going into that, I'm going to talk about my cousin. My cousin Matthew is 21 years old and he has Down syndrome. So he's applied to many different jobs. His most recent was Subway, and they were really great. He made it to the second round of interviews, but didn't get the job. Then he worked for the Ducks baseball team for Long Island, and they were really accommodating, and they would drop him off to and from his house. And it was a really great program to get him involved in the work kind of field. But many people think that just because you have a disability that you're not able to do things like that. So then that's him right there. I put this picture because literally every time we're at a family party, he's always doing schoolwork. Like it could be over nothing, like he'll make up the schoolwork and do it. So I just wanted to like put out there, like he's like literally one of the most hardworking people I've ever met in my entire life. And then I just have an actual story. So he went to community college after graduating last year, and he was sitting in the classroom and the professor called him up and said, you have to leave, like literally just like that. And he got up and he handed him back his paper and he said, you plagiarized this essay, leave. And my cousin, really confused, left, and this is the email between both of them. It's just really important too, like his email was just, he was so lost, and he just kind of said, you mean that I can't pass the class because I used plagiarism on the essay? So I can't go to class. I told my dad that I used plagiarism. You could just tell how lost he was, and the professor said, just, you can't come to my class anymore. So with that being said, my aunt and uncle were away actually for their anniversary, and they came back and they gave a call to the school, and long story short, he wasn't allowed back in the class. And although plagiarism is not okay by any means, the way that the professor went about handling it was extremely unnecessary. My cousin was humiliated in front of his whole class. He didn't even want to go back to school after that, and that's like not like him at all. And then, the professor actually claimed that he didn't know my cousin had a mental disability. I don't know how that's actually possible because it was a class of 15 students and my cousin had accommodations as well. So it was just like kind of an example of like, even just respect, it's really not that hard. And he was discriminated and humiliated, and it really took away from something that he was so passionate about. That's why also accommodations are just important. It makes them feel included in the classroom, the workplace, pretty much anywhere that they are. It just keeps them included and not set aside, kind of like this picture shows. And actually the workplace, they have to accommodate. The only time that they can't is if they could prove that it's an expense or a hardship, undue hardship. And then these are just some examples. So some examples would be job restructuring, modified schedules, flexible schedules, modification or purchase of equipment, proper training, and readers and interpreters to help them. Employers also have to make non-work areas used by employees, such as cafeterias, lounges, accommodated and accessible so that they can equally enjoy and are included with everyone else. So it's not just the actual workplace itself, it's everything around it. And then something that's also misinterpreted a lot of times is if the employer has several qualified applicants, the employer is not required to choose someone just because that they have a disability. It really just, the laws only cover and protect them so that they have the fair opportunity at getting the job still. And so basically just disability discrimination happens all the time in the workplace, and a lot of the times people think that just because someone has a disability that they aren't capable of things like work. And this is why laws are set in place to give them the opportunity that they actually deserve. And then these are our sources.
Very good. Thank you. Around.